Hello friends, my name is Dr. Jigisha Singh and in this video I'm going to discuss about unilateral or charitable promises, and I'm going to discuss about section 25 of the Indian Contract Act, specifically the exceptions under the section. Well, as far as unilateral or charitable promises are concerned, these promises require special division with respect to consideration. As a normal rule, in case of breach, contract can be enforced against both parties, but in case of unilateral contracts, it can be enforced only against one party. A mere promise to pay money for charitable purpose without any request for doing of an act is never enforceable in the court of law. Example: a manager of a school meant for blind students being run on charitable basis. B agrees to pay 5,000 rupees. If B does not pay, A cannot legally enforce it. However, in the same above mentioned case, B says that I shall pay only if special scholarship shared is started for scheduled caste candidates. Then this is a contract enforceable in the court of law. Another example is A announces a reward of rupees 10,000 who walks on foot from Kashmir to Kanyakumari. B, with the free consent, starts his journey. That is, B accepts the offer of A. Now, in such a type of contracts, the party willing to do an act may also say that he would try to do it to the best of his ability, and if he completes the journey, then he is entitled to receive the reward of rupees 10,000 by A. But if he does not pay or refuses to pay, then B can enforce it in the court of law for breach of contract and claim for reward. Now, if B is unable to fulfill the act of walking on foot from Kashmir to Kanyakumari, in such a situation, A, the offerer, cannot in any circumstance force B to complete the journey. So, in such kind of situations, the contract can be enforced only by one party and not the other. Such contracts are called as unilateral contracts. Example: A, along with some other person, decide to construct a temple by raising subscription by tariff. With this mind, they approach B and B promises to pay rupees 500 here. Consideration. Now here, A can enforce the contract of paying rupees 500 to him by B only when some act has been done by A with regard to the offer, like purchasing a property, and if in pursuance of the construction of temple, and if suppose now some act has been done by A, but he does not start the construction of temple, B cannot sue A for construction of temple. Only he can ask for the withdrawal of rupees 500, that is the subscription amount. So, when such unilateral contracts are enforceable, such contracts are enforceable only when the other party, on the faith of the promise and the furtherance of the object of the agreement, does some act or omission and thereby changes his legal position. Thereafter, the promise is called legally enforceable. Now we move on to exceptions as provided under Section 25 of the Indian Contract Act. Now, exceptions where agreement without consideration is valid or enforceable. Well, section as far as subsection 1 of section 25 is concerned, it states that an agreement, section 25 states that an agreement made without consideration is void unless, subsection 1, it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made on account of natural love and affection between parties standing in a near relation to each other. So, if we look into the analysis of this subsection, we come to know what are the essential conditions for this exception. It should be agreement must be between close relatives, agreement must be in writing, agreement must have got registered, agreement must have been entered into out of love, natural love and affection. Now, if all the above conditions are fulfilled, then it is a valid contract, even if there is no consideration. Now, what is the meaning of close relatives? Relationship through blood and marriage is always close relationship. What is the relevance of the above point when which says agreement must be entered into out of natural love and affection when the agreement is between close relatives, because sometimes due to family clashes the close relatives may not have love and affection present. There are two different opinions regarding the same by different high courts, Calcutta High Court and Bombay High Court, on whether close relatives implies love and affection or not. Now, as far as the facts of the case, there was a long-standing dispute pertaining to some land between A and B. They are the real brothers. As a result of this dispute, A and B were not in speaking terms at all. But on the advice from one of their close relatives, both brothers agreed to come under some conclusion. A agreed and said land belonged to B. Second High Court said such settlement made between brothers is the result of still some love and affection left in the heart of the brothers for each other. High Court said that in spite of this bitterness in relation, conclusion was arrived which implied love and affection. The first High Court said, once the parties are not in speaking terms, no question of love and affection left. Such agreements are always void. This is a preferred opinion. If we assume the decision of the Second High Court is applicable, then all the contracts between close relatives would be valid and would imply love and affection. So no use of condition of love and affection in the exception. Now the subsection 2 of section 25 says, it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser or something which a promiser was legally compellable to do. Now, as far as past consideration is concerned, in India, it is always valid in India. If with request of the offerer, it is covered under Section 2D of the Indian Contract Act. If it is without the request of the offerer, it is covered under Section 25 exception. Now, an agreement to compensate a person for an act done voluntarily and without the request of the offerer, provided the act was done in favor of the promiser only, or the act was such which the promiser was legally compellable to do or under a legal duty to do the act. Now, example is act done in favor of the promiser. A son of A is missing. B, without request from A, finds the son and takes him back to A. But after 1 week, gives a reward for past good done. Such agreement is valid under the eyes of law. Now the instance of legal duty. Son of A studying in a school on the last date of examination of board. The son was unable to make the payment. D, the teacher, to save the year of the child, pays the sum of fees. The son of A promises that he would pay to D by getting the money from his father after 1 week. In the given instance, the act is done in favor of the son, but not in favor of the promiser, the father. But the act was such that the father was under a legal duty to act upon. It is covered under exception under section 25 subsection 2, so enforceable. The third possibility, the third section is, it is a promise made in writing and signed by the person to be charged therewith or by his agent generally or specially authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment but for the law for the limitation of suits. Now, third talks about repayment of a time-barred debt or the debt which is void due to limitation of period. For example, D is indebted to C. The maximum period for claiming debt is 3 years. Suppose the period of 3 years has lapsed. C cannot claim now. Since the debt is time-barred, D is under no legal duty to pay back the amount as it cannot be enforced. However, if D promises to pay voluntarily at this point, there is no consideration, but it is valid by virtue of Section 25, subsection 3, if other conditions of Section 25, subsection 3 are fulfilled, which are the agreement must be in writing, it must be signed by the debtor or his authorized agent, the agreement must pertain to repayment of the time-barred debt, and if all the three conditions are fulfilled, agreement is a valid contract even if there is no consideration. With this I conclude. In the next video, I will be discussing about privity of contract. Thank you.